I want to bring in Tim Parlatore, a former member of the former president's legal team and the founder of Parlatore Law Group. Mr. Parlatore, I appreciate you joining us. The special counsel pointed out in his filing today that only two of the lawyers who have appeared on behalf of former President Trump and Walt Nauta have submitted the forms required for obtaining security clearance to deal with the classified documents at the center of the case. Are they just trying to run out the clock, or is that reasonable that only two would have actually applied for it so far, or is that an attempt to delay the trial?
Well, what we're talking about there is a electronic submission of an SF-86. I've done them before. It is a very long thing where you really have to give, all of your addresses, all of your prior work experience, and basically anything that the government may want to look into to see if you have the requisite character to access classified documents. It can take a little while. I mean, it's taken me a week to fill it out, but I don't think that is necessarily, the only short pole in the tent. What I was kind of surprised at with these motions is that they telegraphed right from the beginning that they want to push this out indefinitely. That to me was odd.
Why?
So,
I mean, it is kind of surprising because essentially they're saying it's not just, we want this date. It's we don't even want you to decide when there should be a date.
Right. See, in federal criminal cases, the judge will set a date, and everybody knows that it's a fake date because they have to set the date based on the 70-day clock, and then the parties can consent to pushing it out. But also that clock stops for any number of reasons. Anytime you file a motion, that stops the clock. So, to at this stage kind of ask for the judge to, hey, just throw away the clock is weird because a federal case of this magnitude will take a couple of years generally, even if it's not Donald Trump, even if it's not a politically sensitive case. It'll take a couple of years, but it will get pushed out in increments. You'll push it out, 2 years in 3-month increments, throughout multiple different scheduling orders. And then every time you file a motion, here they're going to file undoubtedly a motion to dismiss. That's going to stop the clock while that's all being litigated. They're going to file a motion to controvert the search warrant. That will stop the clock again. And then once you start to get into, late next year, then they can start talking about their schedule. But the thing is, all of the grounds that they're talking about with it takes longer because of classified documents, a judge prefers to see that after you actually have some track record. Instead of saying, we think it's going to take a long time, if you wait a few months and say, hey, judge, this thing is taking a long time, this is why we need more time, that's where the judge has a much easier way of saying, yes, I agree, let's push it out.
On the idea, though, that only two of the attorneys have applied for, for security clearances for these documents, I mean, I would think this is probably a pretty big case for most of the attorneys working on this thing. So, I mean, if they wanted to move along quickly, I would think they would jump on those security clearances pretty fast, no? I mean, it seems like...
Oh, sure.
If you're trying to slow walk something, trying to slow walk it at every step of the way is the way to go about it.
Well, the government has to initiate those by giving them a link. Not anybody can just log in and create an account for themselves. So one question I have is how many of these, what they call the EQIP SF-86 applications has the government even sent out?
Right. But the fact that Jack Smith is complaining about it,
it's associated.
The fact that Jack Smith is complaining about it in court documents would seem to indicate that they had probably sent out those links. If he's saying only two people responded.
You would think, but they would say, maybe that they sent out links to several different associates, only two of them responded. It's unclear whether they may have only sent it out to, Mr. Blanche and Mr. Keiss, and they were the only ones who have responded. I don't know.
I was talking to Chris Christie last night, who's obviously an opponent of the former president. He's also a former U.S. attorney. He was saying that between now and December could be enough time for everyone to prepare for the trial. Do you agree with that? And if not, what is unreasonable about a December timeline?
I think it's unreasonable based on the specific issues involved in this case because there is going to be significant pretrial motion practice. Undoubtedly, they're going to be filing motions related to discovery, related to dismissal, related to the search warrant. And, I have tried federal cases very, very quickly where December would, very easily be a good timeline. But those are cases where there were no search warrants and there were no other issues where we essentially just waived motions entirely and said, let's go straight to a jury trial. So I don't really see that being as viable in this particular case based on the facts that are in it.
I want some of the other folks on the panel I know have some questions. Elliot?
Yeah, so I too have done SF-86s throughout, or did them throughout my government career, and I agree with your point. They are voluminous, and you've got to pull every piece of information. But my question for you, as someone who's represented the former president, and you didn't quite answer this with Anderson, do you think this is just a deliberate delay tactic? It certainly should be a priority for an attorney to get briefed up and get ready and fill out their background checks in order to be able to zealously represent their client. And I guess just it's really a sincere question. Do you think they really might just be trying to delay this and push this out rather than, it's a hard document to fill out and it takes time? I mean, I just don't think that's that convincing if that's the argument they're making.
I think that the bigger indicator is the fact that they filed a motion asking for the trial to be just continued without any date whatsoever. That's the bigger indicator.
That's the red flag for you.
What the strategy is. Yeah.
Alyssa?
Yeah. And I mean, the truth is, if the two attorneys who filled it out are the two that are actually going to be reviewing those documents, then that's fine. I mean, back with the old team, Jim Trusty and I, we both have security clearances, and the amount of classified documents we're talking about here are not so voluminous that you have to have a huge team of associates, 10 different people to look at them. Having two people look at them, I don't see the SF-86 issue as being the primary indicator of delay.
Yeah, I think what I'd say, though, it's the kind of thing for which you don't really have a ton of recourse, either if you're the government or if you're the court. If they're just dragging their feet on basic things like filing their documents, those are the little things that an attorney can do to try to gum up or slow down a proceeding. And it seems, there's just speculation, it seems that that's the kind of thing that we'd see much more of over the course of this proceeding.
Yeah. One thing to watch for, certainly. Alyssa?
Well, I mean, a judge can certainly impose a deadline on it.
Yeah.
A judge can say, you got to get this thing done by Friday.
And Tim,
I've seen that done.
As you would know, and Elliot and myself, is the government can also expedite security clearances. So if the attorneys were willing to fill out the SF-86 process pretty quickly, I mean, the FBI oversees a large part of that, of course, the Department of Justice. But kind of to the point earlier, do you think that there is an argument to be made that there's kind of a vital public interest in getting this on the road by December, by the end of the year, so it could be adjudicated ahead of the election?
You could look at it both ways on that. Ultimately, the constitutional right to a speedy trial is a right that belongs to the defendant, not to the government. The defendant shall have a right to a speedy trial. And, one thing that I noticed in the government's filings was that they said that they've already turned over in that first group of discovery all of the 3500 material, which is the witness interviews and the grand jury transcripts, which is something that's very unusual. Usually the government tries to hide that until the very last minute. They won't let you see it before motions. You get it really just a couple of days before jury selection. So the fact that they turned that over, within the first batch, which is a radical departure from how the U.S. Attorney's offices usually handle that, that is certainly an indicator to the defense that Jack Smith is trying to rush this to trial as quickly as possible by kind of removing any discovery issues like that. So I can see, from that indicator, that Jack Smith is certainly trying to push this forward.
Yeah. Caitlin?
But, ultimately, is it in the public's best interest? When you have a politically sensitive case like this, it goes both ways.
Well, I think some would argue, Tim.
It depends on what the verdict is, I guess.
I think some would argue that voters should know that before they go and cast their ballots. I think if you were looking at this, though, and their complaints were just about one thing, whether it's the time to get the security clearances or asking for this indefinite trial date, but they're also making this argument, Trump's team is, that they can't get a fair jury before the 2024 election. I mean, do you really believe that?
I don't think that this motion is the best time to raise that. That's something that they would really have to get a lot more evidence of to properly brief under the appropriate rules. And as you guys said earlier, this is Donald Trump, whether he's a candidate or a post-candidate. It is a very difficult, divisive subject. And so I think that they are going to have massive difficulties picking a jury in this. They should, get a pool that's much larger than normal, and they're going to lose most of them right off the bat. But I think that's kind of premature to be raising at this stage. It's a little bit too premature.
We should also point out that's one of the things that Jack Smith said in documents today, essentially that, yes, there will be, special handling, different sort of procedures, but that the courts are well equipped to do this, even if it does require a little bit of extra work.